Hi, my name is Nicholas Height. I'm a lawyer licensed in Louisiana with over a decade of experience committed to working with adult and child survivors of intimate partner violence, stalking, and sexual assault. This video is only informational in nature, and even though I am a lawyer and I am going to be talking about legal topics, I am not giving you legal advice, and nothing I say in this video should be considered legal advice. If you have questions about anything I talk about, or questions about your particular legal situation, you should seek out a licensed and experienced attorney who will be able to provide you with legal advice specific to your needs. This video will help to explain the difference between some common types of restraining orders. I'm going to talk about civil orders of protection, civil injunctions, criminal stay-away orders, and university no-contact orders. I'll talk about what each of these orders generally looks like, but keep in mind that orders can be different depending on your specific circumstances and may not look exactly the same as what I describe. As always, if you need legal advice or have specific legal questions, you should reach out to a licensed and qualified lawyer who can try to answer your questions or address your concerns about your specific situation. All of these orders have some fundamental things in common. All of these orders are intended to limit the amount of interaction people have with one another. They can all be issued with the agreement of the parties, but they can all be put in place over the objections of one of the parties. The types of limitations they put in place, who puts those limits in place, and how those limits are enforced are going to be very different for each of these types of restraining orders. First, we'll talk about civil orders of protection. Civil orders of protection are what most folks are referring to when they talk about a restraining order, and are generally the most common type of restraining order that folks seek out, and forms for seeking this type of court order are available to the public through the Louisiana Supreme Court and the Louisiana Protective Order Registry. As the name suggests, a civil order of protection is issued by a civil court and can be issued on behalf of adults and children. These types of orders can come in a couple of variations, temporary and permanent. Temporary orders can be issued without a hearing based solely on the allegations being made. These temporary orders aren't usually allowed to last longer than 21 days before a hearing must be held and supporting evidence presented. Following that hearing, or if both parties reach an agreement, a permanent order can be issued. While some of the terms of the permanent order of protection can last forever, most only last for 18 months at a time. Civil orders of protection are issued in response to domestic violence, sexual assault, or stalking. These types of orders are enforceable by civil contempt of court, but are also criminally enforceable, and violation of a civil order of protection can result in arrest and criminal prosecution. Next, we'll talk about civil injunctions. Civil injunctions have many similarities to civil orders of protection, but also some significant differences. Civil injunctions are issued by a civil court, and it is possible to get a temporary injunction, also usually referred to as a temporary restraining order, without a hearing, and then later get a permanent injunction following a hearing, or if both parties reach an agreement. Unlike a civil order of protection, a civil injunction can be mutual. This means that a single civil injunction can place restrictions on both parties simultaneously. Civil injunctions can be sought in response to domestic violence, sexual assault, and stalking, but can also be sought in other instances when someone wants to restrain the actions of another person to prevent further physical or legal harm. Civil injunctions are only enforceable by civil contempt of court, which can include financial penalty and the possibility of incarceration. Violation of a civil injunction is not automatically considered a criminal offense and does not automatically make someone eligible for possible criminal prosecution. Now we'll talk about criminal stay-away orders. Criminal stay-away orders are issued by a criminal court as part of criminal prosecution. These kinds of orders can be issued as a condition of a defendant's release on bail, as one of the terms of their probation, as part of their final sentencing, or as a condition of their parole following sentencing. Because this kind of order is issued as part of a criminal case, only the prosecutor, typically the district attorney, or the defendant can request that a stay-away order be issued. Some terms of a criminal stay-away order can be permanent if they're issued along with sentencing or after sentencing. For stay-away orders that are issued prior to sentencing, they usually last for as long as the criminal case remains open and active. Like civil orders of protection, criminal stay-away orders are criminally enforceable as well as being subject to contempt of court. If someone violates a criminal stay-away order, that is a crime and can result in arrest and criminal prosecution. If the criminal stay-away order is a condition of someone's release, either before or after sentencing, the release can be revoked and the person can be placed back in confinement in jail or prison. Last, we'll talk about university no-contact orders. As the name suggests, university no-contact orders are issued by university administration. These orders are not issued by a court and they are not enforced by a court. They typically don't involve law enforcement and are part of the university student conduct or Title IX process. While these orders don't typically involve any limitations on physical distance between parties, they do involve a directive to refrain from communicating or contacting one another. These orders can be unilateral and only restrict one person, or they can be mutual and restrict two people from contacting each other, depending on the circumstances. Unlike most of the other types of restraining orders we've discussed, university no-contact orders are almost always time and location limited. That means that the order may only apply to parties when they are on university property or participating in activity related to the university, and generally the order can only last for as long as the parties are each enrolled at the university.